Hotels that enable sex trafficking can be sued. What every survivor should know. Attorney Andrew M. Stengel. Hotels and motels are among the most common settings for commercial sex trafficking in the United States. Traffickers rely on hotels for the anonymity and flexibility that short term cash transactions provide. And for years, many hotel chains looked the other way. Hotels failed to train staff, ignoring obvious warning signs. Hotels profited from sex trafficking by accepting revenue from trafficking operations without asking questions. Under the federal TVPRA and New York State Social Services Law, Section 483-BB, hotels that knowingly benefit from sex trafficking on their premises can face significant civil liability from sex trafficking lawsuits. Multiple major hotel chains have already faced TVPRA litigation, with some cases resulting in substantial settlements on behalf of survivors. What warning signs do hotels ignore? Courts have found that hotels knew or should have known about trafficking when staff observed various signs. Hotels knew or should have known about sex trafficking from guests paying cash for multiple consecutive nights, requests to avoid housekeeping, large numbers of men entering and leaving a single room at all hours, and guests who appear fearful or controlled. Other obvious signs include excessive quantities of condoms or toiletries, visible signs of physical distress, and minors in rooms booked by unrelated adults. These warning signs are powerful evidence in sex trafficking lawsuits. The legal standard, knew or should have known. The TVPRA and New York State Social Services Law do not require proof that hotel management had actual specific knowledge of trafficking. The statute's knew or should have known standard is deliberately broad. The laws are designed to reach commercial entities that profited from trafficking by turning a blind eye to obvious evidence. Hotels that received complaints from staff, guests, or law enforcement and took no action face particularly strong liability exposure from a sex trafficking lawsuit. Corporate defendants and insurance coverage. Hotel chains often carry substantial commercial liability insurance coverage. When trafficking occurs at a franchise property, both the franchisee and the franchisor may face liability. That's particularly true if the brand's training materials or operational policies fail to address trafficking prevention. Identifying all potentially responsible corporate entities is an important early step in hotel trafficking litigation. Building the case against a hotel in New York. Evidence in hotel sex trafficking lawsuits includes booking records, check-in and checkout logs, security camera footage, staff incident reports. In addition, prior law enforcement contacts with the property, Occupational Safety and Health Administration, and health inspection records and testimony from hotel employees is also important evidence. An attorney will issue evidence preservation letters immediately upon retention to prevent the destruction of critical records. Contact us now for a consultation. If you were trafficked at a hotel or motel in New York, the property may be legally responsible for what happened to you. Contact the law firm of Andrew M. Stengel, PC, for a free confidential consultation to learn about your rights. Schedule a consultation with the law firm of Andrew M. Stengel, PC, by emailing info@stengellaw.com. For more information, please visit our website, stengellaw.com. Attorney advertising. Prior results do not guarantee a similar outcome.